Good morning. Please be seated. First case on calendar is Muñoz versus Manhattan Club Timeshare. We'll hear you now.
May it please the court, my name is Jeffrey Deichman. I represent the appellant, the Manhattan Club. The judgment against the Manhattan Club for over $750,000 for retaliation should be vacated as a matter of law because there is no causal connection between plaintiff's complaint of discrimination in April of 2010 and the termination of his employment some 10 months later in February of 2011. There are three key reference points which demonstrate that there's no causation as a matter of law. The first is the May 4th, 2009 memorandum received in evidence which memorializes a meeting between Manhattan Club management and plaintiff where plaintiff was told about all of the complaints management had received concerning his behavior and his interaction with other co-employees.
There was also testimony at trial from co-workers that he was charming and appropriate in his behavior.
He brought two friends of his in who did not share his shifts and only maybe overlap for a half an hour. And therefore they were
our friends like us, presumably, but the jury can accept what the friends say as opposed to his enemies.
But these were complaints from not only the housekeeping department, but from the sales department and the engineering department that took place in June of 2009, months before he ever turned in his doctor's report, months before he ever complained of discrimination. That took place in February and April of 2010.
But they didn't fire him then.
They didn't fire him. They sat with him, they spoke with him, and they said, this kind of behavior cannot be tolerated. You need to improve. And they gave him every opportunity to improve. And then what happened, which is the next key reference point in terms of the lack of causation, is in 2010, in September of 2010, there was an anonymous shopper's report. We call it the mystery shopper. The president, Toby Pike, who testified at trial of a company called Diamond Hospitality, came in anonymously and evaluated the facilities and personnel. And she criticized, both in her report and her testimony, she criticized plaintiff as having failed to live up to basic hospitality standards. And he admitted as such.
Based on one incident.
Well, based on her interaction.
Well, she didn't actually interact with him, right? She was interacting with somebody else and he came up.
She was interacting with the receptionist and he came and interrupted that proceeding, dumped a bunch of papers, and basically admitted his bad behavior. On cross-examination,
But of course, the shopper also criticized pretty much everybody at the club, didn't she?
The other people she criticized mostly were union employees, not people in management roles. The only management other person that she criticized was a criticism for not following up on recommending Angelo's Italian restaurant.
That's my concern here. We are not the jury.
Yes.
We are not trying this case. There was a trial. And all of these arguments certainly could be made because you do have a triable case, but they were rejected by the jury in its verdict. And so we have to look at all of this in the light most favorable to the verdict that was returned. And there, what we've got is escalating complaints, possibly including a phony customer complaint, after a request for accommodation. And I'm not sure why the jury could not conclude that the escalating complaints after the accommodation, particularly if it were to conclude that one of them was phony, did not support a conclusion that this was a retaliatory discharge. So tell me why, as a matter of law, no reasonable jury could have found that.
Right. I'm making the legal argument, not an argument to the jury.
Well,
and
but
that's
you
why
have been arguing that this is how this evidence should be seen, and we have to view it not as you think it should be seen, but you have to argue that no reasonable jury could have found these set of circumstances to evidence retaliatory discrimination. And I think particularly with the possibility that one of these complaints was phony.
Let me start with that. Let me start with the last complaint. Which
and just remember, I'm not interested in why you don't think it's phony. You have to convince us that no reasonable jury could have thought so and drawn therefrom an inference that they were looking to retaliate.
Well, let me say this, that there was no evidence that it was phony. It was just an argument that was made by counsel. We've shown the handwriting exemplars that were received in evidence, and even somebody from another planet would have immediately recognized that the handwriting was not the same. There's not a shred of evidence that that was phony. We had our HR director testify that he was there on December 12th when he checked in guests of an owner when they had to move from one room to another room. And the complaint, which called him unfriendly and impolite, identified him by name in San Antonio. And the argument that I'm making is a legal argument. It's a lack of causation, number one. And it's because the complaints took place before he ever complained. There couldn't be retaliation if there were complaints against him in 2009 when he first complained in 2010. Number two, I'm saying there were intervening causes. The shopper's report was not something created or manipulated by the Manhattan Club. It was an independent outside organization. The guest comment card was not something that was proven to be a fake by the plaintiff. It was an outside guest who was putting in those comments based upon an interaction with the plaintiff. These are intervening events. And regardless of the fact that the temporal proximity...
I don't understand. How do we know that those things were the cause exclusive of retaliation? I mean, lots of employees have complaints against them in your business and in any other business. And the employer makes decisions then based on the total mix of information available. So I understand that you can point to problems that Mr. Muñoz had before he engaged in protected activity. I understand that you can point to some evidence that he had some problems after that. But there's also another event, which is his engaging in protected activity. You're saying, oh, it couldn't have been the cause. But why isn't that exactly what we ask juries to decide when there's a mix of different information, a mix of different possibilities, and they decide which ones they credit?
Your Honor, I think under these circumstances, we've cited case law where after the request for protected activity occurs, if there is an intervening event that is not something manipulated by the defendant, which is what we have in this case, two intervening events, that breaks the chain of causation as a matter of law. And those are based on cases that we've cited from this circuit. It breaks the chain of causation. And it doesn't mean that there was a pretext for his poor performance. It shows that they relied upon legitimate outside sources in order to conclude that. And the only other thing I want to mention, I see my time is rapidly expiring, I want to mention the punitive award. I think the punitive award of $347,000 is not only outrageous, but it's unwarranted and it's excessive. I think even Judge Lynch, in a case that you decided when you were a district court judge, you said that rarely in this circuit are $300,000.
Even I?
Even you. You joined the large group of judges who all agreed that these kind of punitive awards should be remitted. They're remitted to as low as $6,000. You cited that case in your decision, say, against UBS in 2008.
Your adversary's brief says on page 2 that at trial, your client argued only that Muñoz had failed to make out a claim for liability as to retaliation and failure to accommodate it said nothing about punitive damages as a matter of law, time of its Rule 50 motion or any time thereafter. So is that so? And if not, where did you raise that issue?
Well, we consistently argued that the Manhattan Club acted in good faith. And we cited the same documents we're relying upon here, showing that they were entitled to rely upon these outside sources. That is the very antithesis of malicious and egregious conduct. That is exactly what thwarts the idea of punitive damages. They never raised that waiver issue, by the way, on the motions to the district court. I would submit that they waived that issue.
Yeah. So what you're saying is whenever someone makes a Rule 50 motion saying there isn't discrimination, there isn't an intent to discriminate as a matter of law, that encompasses the idea that if there is, there nevertheless was not willfulness.
I think you don't have to use the magic words punitive damages as long as you focus on we acted in good faith, we didn't act egregiously or willfully.
And may I
$347,000, and it seems to me that if you're going to make these arguments, it probably would have made sense to make them to the district judge. The district judge could focus specifically on whether punitive damages are appropriate. I mean, discriminating against somebody for a disability is already is blameworthy to start with.
It's blameworthy to start with, but when you look at some of the cases that we've seen in the circuit and elsewhere, and what the Supreme Court said in the Gore case, it's the degree of reprehensibility that is the most important factor. There was no physical abuse. There was no verbal abuse. Manhattan Club acted in good faith.
May I suggest I asked whether you're making a slightly different argument. One argument is that there is no evidence warranting punitive damages as a matter of law. And that's an argument that could be made in a Rule 50 motion. There's a different argument that the amount of punitive damages is excessive, and I'm not sure that can be made in a Rule 50 motion at the close of the plaintiff's case, because you don't know how much the jury awarded. So are you also making a remediator argument? You made a remediator motion below as well?
Yeah, absolutely. We made that argument before the district court. We're making it here. And that's correct. We say it should be vacated as a matter of law, but if not, it should be substantially remitted. And we've briefed many of the cases that Your Honor cited and that this court in the circuit has cited. Punitive damages are routinely remitted when they're at the $300,000 or more level.
You've reserved some rebuttal time?
I've reserved some rebuttal time.
Hear you then.
Thank you.
Good morning, Your Honors. You may it please the Court, I'm here with co-counsel Steve Bergstein, and as you know, this is not the Supreme Court of Credibility. I'd just like to answer something that you asked counsel, Judge Lynch. They made a remediator motion as to compensatory damages only. They made a strategic decision to the judge to say that the punitive damages should be thrown out as a matter of law to zero. That's a strategic decision because you asked the judge all or nothing. And they gambled with that decision, and the judge agreed that despite the waiver, which he didn't even reach.
If there was a remediator with respect to the compensatory damages, surely that would have immediate impact on the scale of the punitive damages.
Since
limited to be proportional in certain respects.
Since they are supposed to be proportional, yes, but there was.
Saying they didn't argue that even if the compensatory damages were not remitted, the punitive damages should be. They never made that argument.
That's correct. I think that when you're talking about the ratio, which the judge upheld in its entirety, and we stipulated to back wages, the ratio in this case is 1 to 1.29, which is well within constitutional limits. The last decision that this court has reached on punitive damages, the plaintiff won $150,000 remitted and $100,000 in punitive damages, so that's approximately 0.8 to 1. Are they exactly the same? No, but they're within the range of constitutional limits. And in Stamp, the remediator argument wasn't waived below. The court found solely that it was a basis of constitutional limits because it was so excessive. It was in the millions or something like that. And here we have a very close ratio. Now, as Your Honors have pointed out, this is not a court of credibility. This is not the jury. And the jurors were entitled to find, even though they didn't have to find, that this was an excellent employee who loved his coworkers, he loved his job. There were many positive customer reviews in his file. There were individual letters from his managers and from one customer whom he tried to accommodate to get her to stay in the hotel with a bucket of candy. He won the Manager of the Quarter Award in 2008. He had congratulatory letters from his managers and thank you letters from his coworkers. A good evaluation in 2008 raises.
I mean, we are not a jury, and so we can't elect him Employee of the Month. But I take your argument that there's arguments on both sides of this. Your adversary started out arguing that there's no proximity argument that can be made here. That you're looking at a 10-month break between April 2010, when the accommodation was requested, and February 2011, I believe, when he was fired. And I take it your responsive argument is that there are intervening acts.
Yes.
And bridge that.
Absolutely, Judge Jacobs.
On page 12 of your memo, you say, while the jury found accommodations were granted, and Muñoz doesn't appeal this finding, it's in the memo, plaintiff contends that the repeated revocations of the accommodations, however small, were acts of retaliation.
Yes.
Now, it looks to me like there's a sort of a contradiction there, which may sidle up to an issue of law here, where you don't have a pure proximity argument, but the only things that take place in the 10-month interval are what you call small acts involving revocation of accommodations, but the jury found that he was accommodated.
Well, I think that these are easily reconciled. The club we have accepted on appeal did give him the accommodation under duress. He had to try first to accommodate the hotel, but then their lawyers told them you have to give the accommodation. But if you look under the ADA, Section 203 on retaliation, the retaliation clause includes a reference to interference, coercion, or intimidation. And if you look at the Burlington Northern case, Justice Breyer says that a schedule change in an employee's work may make little difference to many workers, but may matter enormously to a young mother with young children. So you take out young mother with young children and you put in a person who needs to take a medication at night, and that schedule change becomes a retaliation. And that was what Burlington against us.
Is that interference or coercion or intimidation?
All three. All three.
What were they intimidating him into doing?
Well, our contention at trial is that they wanted him to quit. He contended that he walked in to work every week to look at the schedule and was afraid that he would be on the night schedule. And he didn't know that he had the certainty that these accommodations would be granted.
And the evidence indicates that if he had to work at night, and not only would he be drowsy, but that the effect of the medicine would be impaired.
That's absolutely right. It would hurt the hotel and it would hurt him. And that's what he found the first year that he took the medication, that it wasn't working. And it was only then that he asked for an accommodation, got a little tension, went back to see if he could change his medication to something else, found that he could not, and the accommodation was granted. But it was not only the revocations of accommodation that were retaliatory acts here. There was, number one, the silent treatment and the exclusion from some meetings. There was the vituperative 2010 evaluation, which called him a whiner and a complainer. The district...
Excuse me. Is the point here that you're not really relying on a proximity argument as such, where you don't need to rely on that argument because the jury could have taken the whiner and complainer reference as direct evidence of retaliatory intent?
Absolutely. I think that the cases, and even the case that they cite, the City of Waterbury, a District of Connecticut case, says that 1 year is the maximum if you're relying on timing alone. We're not relying on timing alone. We think that the timing is within the months that you are allowed to assert timing as a causation. But in those 10 months, there was the silent treatment, exclusion from meetings, the vituperative evaluation, the disparate treatment in response to the shopper's report. He had 2 sentences in his shopper's report out of a 50-something page memo that went down to every wire an improper sign in the hotel.
How many contacts did the shopper have with him? I mean, I'm aware that the shopper said he brought papers over to someone who was dealing with a patron and did not apologize to the patron for the interference. But were there other encounters that the secret shopper had with your client?
No, it was a 3 or 4 second, and it was a 3 or 4 second. They both agreed to that, and the secret shopper, not to be too dramatic on appeal, but the secret shopper said that he handed her a stack of papers this high when the evidence was that there was only a bill or something, a folder that they would be handing him. So she embellished her testimony, and she was an interested witness. She works for this hotel. She has their name on her website.
She was an independent contractor.
Well, yes, she's an independent contractor, but she's still an interested witness.
But they're a client of hers.
They're a client of hers, and their name is on her website, and she wants to keep it there.
Their name is on her website
yes.
As a client.
As a client. And they want to keep...
You're saying a jury could conclude anyway that she had an interest, whatever her interest was. She may have been a neutral reporter at the time she wrote her report, but by the time she gave testimony that you contend was embellished, she has an interest in reaching the conclusion that the company reached.
Absolutely. Absolutely. And then after that, as Your Honors have pointed out, we made a clear showing that the anonymous complaint was a forgery. They have an index of complaints as they come in. This one came in December, and yet it was not logged in to their December 2010, not January.
When you said came in December, you mean it's dated December?
It's dated December, and it was not logged as if it had come in December. And then with the number on the number of the room in which the complaint came in, they had to justify that room with a convoluted scenario wherein the customer complaint really put down the wrong date. It was not, there was one person that he checked in on that date, Sarah Levy, and they said, oh no, it wasn't Sarah Levy, it was someone else who was in it, who was a guest, and she really wrote down the wrong number. And it wasn't logged into their contemporaneous records, something they never explained at trial. You see, my time has run out. Do you have any other questions? Thank you.
Your rebuttal.
Plaintiff admitted to his poor behavior in his interaction with the shopper. He was asked on cross-examination, you didn't excuse your behavior to the shopper, true? True. You didn't apologize to the shopper, did you? True. You didn't say anything to the shopper, did you? No, I did not. You just stared at her, right?
I mean, it
yes.
is not. It doesn't seem to me like the most outrageous experience a patron or customer has, that while they're dealing with somebody face to face, somebody drops some papers off at their desk. I beg to disagree. You could apologize for it, I suppose, but if you're dealing with 3 to 4 seconds worth, and I don't see why a jury couldn't basically say for 3 or 4 seconds anybody can be in a bad mood.
I beg to differ because there was a lot of testimony about, and even from the plaintiff, what are the basic requirements in the hospitality industry, which is very competitive. You have to smile all the time. You have to greet people. You have to excuse yourself.
Maybe the jurors are people who go to hotels a lot and get a little tired of all of the have a nice days and don't think the same way. But I mean, that's their choice.
And the question isn't whether you should or should not have fired him for that reason, because if you fired him for that reason, that's not the law's concern. But am I right that the day he got fired is the day of this card incident?
The guest comment card? No, the guest comment card came in December of 2010.
Right. By
the time it got processed and moved up to management, and by the way, management in October told him if there was another complaint, he would be fired.
I'm not asking you to go into it. What is the relationship between that event and the day he gets fired?
When management got the guest comment card and got together and decided that he was given a final warning and this was a legitimate complaint from the guest, they got together in February of 2011 and decided to terminate his employment. That's what happened.
And so to the extent that the jury could have found that card, which seemed to figure in his firing, was not genuine, they could have found that the reason you fired him was not a concern with his interaction with customers, but rather that it was retaliation.
Well, of course, that was just the timing of the issue with the card. His termination was based upon an accumulation of events that went back over the year.
If
it wasn't just the
didn't
card.
Credit that. I mean, that was your argument to the jury. But they could have concluded from, the statement about him being a whiner after he files the claim of protected activity, and this, if they were to find that the card was not genuine, that this was retaliation, not really a concern with conduct that you'd put up with for a long time.
No, with all due respect, Your Honor, let's put that whiner statement into context. It actually says he's developed
a lose as soon as you say put it in context. Because isn't it for the jury to decide whether to put it in context, whether your argument about what it relates to or doesn't relate to is accurate?
But it says he had a reputation as a whiner and complainer. The only people who knew about the accommodation were senior-most management, not his coworkers, not the people who developed and considered his reputation. And that talks about his relationship with his coworkers. There's nothing about complaining about discrimination.
The person who wrote that know about the request for accommodation?
I believe so, sure.
So then when someone who himself might have a motive to say the guy's a whiner because he wants an accommodation, has an interest in saying there's a reputation. Why do we have to credit his report of reputation? And then, all of these are just issues of what do you believe happened and whom do you believe and whom do you trust?
I don't believe so, because the words about whiner talk about his relationship with other departments, his relationship with coworkers, not a thing about discrimination. And going back,
explaining to us, though, why the jury has to have credited that as opposed to have accepted only as someone who knew he wanted an accommodation is now papering the record with complaints about him as a whiner and complainer.
And where does this forgery thing come in? I know Your Honor mentioned that again. Where does that? What evidence of forgery?
You suggested there's not a smidgen of evidence.
That's correct.
In fact, there's a whole host of evidence that it was a very unusual document, that it didn't match up to a room. I mean, I know you all tried to explain this, but the jury did not have to credit it. The question is not whether we think you've got the better explanation, but whether any jury could have found that this was trumped up.
I understand, but I still say that the temporal proximity of 10 months between those two incidents is more than sufficient to demonstrate as a matter of law that there was no retaliation. And I think we cited ample cases to support that proposition.
Thank you. Thank you both. We'll reserve decision. Next we'll hear Baez versus JetBlue. Morning.
Good morning, Your Honors. May it please the Court. John Norensberg on behalf of Plaintiff Appellant Rosalinda Baez. There are a number of issues I would like to address with the Court today. I'd like to start with the immunity issue. The Supreme Court has left open the question of whether ATSA immunity should be decided by a judge or by a jury. So it's an unsettled question, and it's unsettled in this circuit. Based on the fact that it's an unsettled question, the district court was under an obligation to follow the law.
Immunity in all kinds of other contexts. Why wouldn't the analysis be the same, namely that we view the facts in the light most favorable to your client on summary judgment, and then we decide whether those facts would support immunity?
Well, to me, that is a proper way of doing it. I mean,
all right, so why don't you tell us why, if we analyze it that way, there's error?
Because the district court based its immunity analysis on clearly erroneous facts, and not just one or two facts, but essentially the entire scenario upon which immunity was granted was based on non-existent facts. The district court erroneously found that this complaint was immediately reported to the TSA. The TSA immediately responded that the TSA interviewed.
Why don't we put aside the district court's version? I think what Judge Raggi asked you was on the facts, taking your version of the facts, why, as a matter of law, isn't there immunity?
Okay, because under this court's jurisprudence, under immunity jurisprudence, there's a very clear, sharp factual dispute as to what was said to.
Yes, but assume we take your version.
My client's version was simply this. She asked two rhetorical questions in rapid succession. One, isn't it illegal after 9/11 for a plane to take off without a customer's bag, with a customer's bag without the customer being present? And what if I had a bomb in my bag? Those two questions are right after each other.
All right, so let's focus on the second one. The obligation under the statute is to disclose any suspicious transaction relevant to a possible violation of law relating to a threat to an aircraft. It's extremely broad language.
Right.
And I mean, to be blunt, why isn't the use of bomb and aircraft in the same sentence suspicious activity that you would want reported to? Notice of the United States Court of